Well, welcome back to All Day Live. We want to catch you up on some more headlines here. This one caught our attention. 23andMe has filed for Chapter 11 bankruptcy protection to help the genetic testing company facilitate a sale. It's been years of financial issues now. They're a California-based company, and they've just really struggled to find a profitable business model since they went public. It was 2021 when that happened. We wanted to find out a little bit more about consumer rights when something like this happens. So joining me now is Monique Hayes, an attorney who specializes in bankruptcy practice. Monique, thank you so much for joining us. We appreciate it.
Oh, it's my pleasure. Thank you for having me.
So first of all, let's just start at a very top level. What is Chapter 11 bankruptcy in a case like this? What does that look like for this company?
Okay, so a Chapter 11 bankruptcy is an operating type of bankruptcy, not as a liquidation that's turned over to a court trustee to administer the process. Instead, in a Chapter 11 bankruptcy, the business is coming up with some sort of plan to treat its creditors over time. Sometimes that's in order to have a turnaround and continue with its operations, or sometimes, as in what we're seeing in the case of 23andMe, it is for a plan that would allow them to orderly liquidate their assets, sell their property in order to get the highest return in an effort to give something significant back to their creditors.
Okay, so how do consumers who have signed up for 23andMe and given their very, very personal information, how do they fit into all of this, and do they end up falling through the cracks in something like this?
They could end up falling into the cracks. So it is important that consumers pay attention and have an understanding of what their rights are. So first, both in the bankruptcy and outside of the bankruptcy, the consumer's rights are defined in the agreement with the company here, 23andMe. So the first thing consumers want to do is to have a copy of the contract that they entered with 23andMe. And a lot of times, if they initiated the agreement online, they don't realize it, but consumers actually have an agreement, and that agreement is the service agreement that is online when you signed up for the service. So you want to download a copy of that, as well as the terms of service for the website, because that will be the first place that defines what the consumer's rights are. Okay?
Yes.
And then in the bankruptcy proceeding, there are times where the rights can be modified, meaning 23andMe may, as a part of the bankruptcy, try to change the terms of that contract. If that is the case, they would have to send notice to each of those consumers through the mail. So in the coming days, it will be very important for the consumers to pay attention to their mail, including their email, if that's where they got notices from 23andMe, because that's where they will learn details that affects their contract in the bankruptcy proceedings.
And obviously every contract is going to be really different for different companies. In a case like this, though, so are you saying, is it possible that in sort of all the fine print and the contracts that we always just kind of check and never really read, right? We're all guilty of that, that they could say, yes, you did sign up for this and you trusted us with your personal information, but in the case of a bankruptcy or, whatever, that may be null and void, and your information could then be shared. Is that kind of what you're getting at?
That is correct. So those types of provisions would be in that contract. So in the case of 23andMe specifically, their agreement, their standard agreement, and this may be different. So each consumer needs to download the agreement because they change over time. Depending on the year that you took the service, the terms may have changed. So you want to understand the terms that apply at the time that you entered into the agreement. But their standard agreement at 23andMe does contain a provision that gives them a right to, in the event of bankruptcy, to sell certain data that is consumer related, including the results from consumers. And so that is a provision in the contract. I wouldn't immediately assume that that provision is valid and enforceable, but we want to know if it's there. That's the starting point.
Okay.
And then from there, we would want to know if it is enforceable either in bankruptcy or outside of bankruptcy. And that would be a part of the discussion. So that's one sliver of concern, whether the data can be sold. Another point of concern that will also be addressed in the contract is who actually owns that data. Generally, DNA and DNA results belong to the person that they relate to. So your DNA cannot be sold without your consent. So the question is, did you ever give your consent for that sale? And how I would know that, or how we would know that, is by looking at that agreement. So we need to look at the agreement that applied when each consumer took in the service, to understand whether 23andMe has the right to sell that information.
Okay. So let's say let's just say in a worst case scenario that your personal data, your DNA does get sold and it's out there. Is there recourse or not? Or did you sign it away?
That is what may be different in each case. Okay. So we want to see what's in the contract.
Okay.
And then even if you find out as a consumer that there was a provision that said you have essentially sold it away, you should not just walk away and concede that that is enforceable, or that it has been sold for any and all purposes. That will be an issue that will need to be addressed in the bankruptcy proceedings, and the consumers may be heard. So for instance, if you consented to the release of your information, and you perhaps were even aware that it contained a fine print that the information could be sold in a bankruptcy, the type of sale may make a difference to you. It may make a difference if it's being sold to a similar company, or if it's being sold to a company that has never been vetted and never been heard of, and you don't know what they're potentially going to do with your information. So in that type of scenario, then as a consumer, you do want to pay attention to the bankruptcy proceedings to understand not only if there is going to be a sale, but to whom the sale could potentially go to. And if you have the opportunity to voice your concerns as a consumer in the bankruptcy proceedings, including objecting to a particular sale or a particular purchaser, that will be the time that you will receive notice and the opportunity to be heard.
Wow. This is a lot, Monique.
It is.
I mean, I feel like, you would almost need to have someone like you kind of, in your life to be able to say, hey, Monique, this is happening, and to walk you through everything, because there's so many different layers here. Is there a bigger sort of consumer beware message that you would give here for anybody signing up for, anything like this, no matter if it's personal like this or not, given your expertise here?
Yes, absolutely. Nowadays, in any type of agreement that you're entering into, especially ones that originate online, and if it's for personal services, but I carry that if it is also for an substantial amount of money that you are either investing or using for a service, or if it's a personal service that relates to something substantial or personal. That could be your personal identity, your DNA, a large sum of money. You want to, before you actually take the service, make the payment and sign the agreement, including a digital signature. Consumers need to be aware that digital signatures are enforceable the same as a wet signature with a pen. So you want to know before you sign on to the agreement what the terms are. So download them, have a copy of them, the service agreement, as well as the terms of service for the website. And then if you can, consult with an attorney before you enter into the agreement. But even if you are not able to consult with an attorney, you still should at the very least understand the agreement yourself. So when you are able to review it, download it before you sign up, before you pay, make sure you understand what happens in the event that the company closes, in the event of a bankruptcy or another type of proceeding where the original company that you entered into the agreement with may be changing. And that may include a sale outside of a bankruptcy scenario. You want to understand that the agreement that you entered into will be honored. And if there is a circumstance that it may not be honored, you want to understand what that circumstance is. And the best place to start to understand that is with the actual agreement. And then outside of that, it is with your state and local laws that may govern these types of transactions.
Okay, wow. Good advice. So yeah, investing, spending a lot of money or giving away very personal information like this, definitely, think and read through everything that you can beforehand. Monique Hayes, partner with DGIM, we really appreciate your time today, and hopefully this turns out as well as possible for folks who have given their information to 23andMe.
Yes, I'll be following along, and if I have any more insights, I'll be happy to share.
I appreciate it very much. Thank you for your time today.
Oh, my pleasure.
All right, take care, Monique. Thank you.